Morning, everybody. I want to welcome everyone to the Interim Joint Committee on Judiciary. I apologize for starting a couple of minutes late, but we had a medical emergency with Representative Nemes and his finger and a terrible zipper incident with his folder over there. Folder zipper. But anyways, no joke. He was bleeding, and we needed to get that taken care of, and I wanted to let members that were still trickling in come in. All right. Madam Secretary, wherever you are. There you are. Call the roll.
Senator Berg. Senator Carroll.
Here.
Senator Carr. Senator Neal. Senator Schickel. Senator Schroeder. President Stivers. Senator Turner. Senator West. Senator Wheeler. Representative Banta.
Here.
Representative Blanton.
Here.
Representative Bratcher.
Here.
Representative Cantrell. Representative Decker.
Present.
Representative Elliott. Representative Fisher.
Here.
Representative Flannery.
Present.
Representative Heverin. I'm sorry.
I've been called a lot worse. Present.
Representative Kulkarni.
Present.
Representative Lewis. Representative Maddox.
Here.
Representative McCoy. Representative Minter. Representative Mosier. Representative Nemes.
Present.
Representative Petrie.
Here.
Representative Scott. Representative Stevenson. Co-Chair Westerfield.
Here.
Co-Chair Massey.
I know Chairman Massey is en route, and he'll be here just a few minutes. All right. Anybody have any guests or anyone they want to recognize before we jump in? Okay, seeing none. It gives me great pleasure to welcome back to this committee the Chief Justice of the Kentucky Supreme Court, John D. Minton, Jr. The Chief Justice had an opportunity to speak before my committee back during session, and that didn't go so swiftly. I wanted his last time to come before the committee to be a little more positive and upbeat, and have, as I have each year, or just about every year I've been the chair, give him an opportunity to give a State of the Courts address and tell us whatever he feels he needs to share with the legislative branch about the state of the court system here in Kentucky. Chief, first things first, my mother says hello.
I return that hello to a fellow Warren County.
That's right. I will do that. And I learned earlier this week from a fellow member of the bar who had terrible things to say about you. David Broderick mentioned that he is the reason for your great success.
Yeah, but for David, I'd still be practicing law.
Chairman, before you start, make sure your microphone's on.
All right. Thank you,
All
Mr. Chairman and members of the committee, Chairman Westerfield and Chairman Massey and Rout, and members of this committee and guests. Good morning. My name is John Minton. I'm the Chief Justice of Kentucky, and I want to thank you for inviting me to join what would be, I guess, my last appearance before this committee as Chief Justice, and I thank you for this opportunity. Mr. Chairman, if you'd allow me really a moment of very personal privilege.
Of course.
Today, if I were to give the state of the judiciary at this moment, the state of Kentucky's judiciary is sad. We're saddened by the death of Judge Tom Emberton of Edmonton, who passed away overnight. Judge Emberton was my chief judge when I joined the Court of Appeals. He was the chief gentleman of the Commonwealth throughout his entire life. I'm sure that everyone in the Commonwealth will join me in saying Kentucky has lost one of the finest people that we've ever known, finest public servant, and a great example to all of us. And so I wanted to begin my remarks by calling that to our collective attention and expressing on behalf of the Court of Justice our deepest sympathy and condolences to Julia Lee, his wife, and to his children, Laura and Tom, and grandchildren.
Chief, thank you for that. You shared that before the meeting, and I wasn't aware of that news, and that is a terrible loss for the Commonwealth of Kentucky. Thank you for bringing that to our attention, and we'll certainly keep Laura and Tom in our prayers and the rest of the family. Thank you, Chief.
Yeah. Since I'm not seeking re-election for another term, my days as head of the judicial branch are quickly coming to an end. And so as you can imagine, it's a bittersweet time for me as I look back over 30 years plus on the bench as a justice on the Supreme Court, a judge on the Court of Appeals, a judge on the Circuit Court. And look ahead to my retirement, which is kind of an unknown territory, to be honest. People ask me what I'm going to be doing, and I'm not exactly sure. I will have more time for my family and my grandson, who lives in Nashville, and for my gardening, I guess, that'll take up a little time, and the bees that I try to keep, and for the opportunities that lie ahead that I have yet to really identify. But today, I want to share some of my reflections of this 14-year journey leading the judicial branch, and I'd like to give you a glimpse of what I predict would be the future for Kentucky's court system. There are many unknowns when one takes on a new job, and that certainly was true for me when I was sworn as Chief Justice in June of 2008. I could not have imagined what lay ahead for me in terms of unprecedented challenges, but neither could I have anticipated the scope of what we were about to accomplish. The first challenge that I encountered would be addressing what's been now known as the Great Recession. I hope that there's not another recession that overtakes it as greater, but a Great Recession. The early days of my administration were roiled with the Great Recession, considered to be the worst economic downturn in our country's history. Major budget cuts left all three branches of Kentucky's government reeling, and by 2012, the judicial branch was forced to furlough employees. For the first time in modern history of the court system, we had to close courthouse doors for several days in order to balance the budget. At the same time, there was no pay equity plan, no funding for the pay equity plan to make judicial branch salaries competitive with the rest of state government, or for the capital projects that we felt we needed to replace the court system's obsolete case management system, which was at that time at great risk of failure. The Great Recession took a tremendous toll. After several years of lean budgets, we laid off 282 employees statewide. We eliminated court programs and trimmed court operations at all four levels of the court system. If any good came out of that grim experience, it was this. We learned how to quickly react when faced with a crisis. We learned how to streamline operations and still meet our constitutionally mandated responsibilities. We learned collectively how to gather the grit that would come in handy when the next big thing hit in March of 2020, and that, of course, was the COVID-19 pandemic. On March the 6th, the governor declared a state of emergency after we confirmed our first COVID case here in Kentucky. As society shut down, the courts were forced immediately to move from in-person to virtual operations, really turning on a dime to reinvent our entire way of doing business. You know, I can think of no other event in my professional lifetime that has created more prolonged disruption, and I'm sure you all, I really am not telling you something you all are not very, very aware of, but disruption to the courts than the COVID-19 pandemic. Despite this disruption and despite the restrictions of in-person traffic in court facilities, I'm really very proud that our courts never closed. Court proceedings were certainly unconventional as judges, tried to find a way to hold court, and we turned to Zoom, really a word I had never heard of before. We quickly not only learned to say it, we learned how to find it and how to do it. But the hard work and extreme patience of our judges, our circuit court clerks, and our court personnel helped us to weather the storm. And although the Supreme Court has lifted all the restrictions for in-person proceeding, it's back to business as usual, I hope, and Mr. Chairman, I'm sure you will join me in this hope, that we retain some of the lessons that we've learned during the pandemic and continue to make available virtual court appearances whenever we possibly can to accommodate lawyers, their clients, people that we serve.
It's like you wrote that part just for me.
I
Chief.
did. In fact, if you'll look at the script, I actually added that myself because I know I've heard from the chairman how strongly he feels about this topic, and I know there are others who do as well. In spite of the numerous challenges, large and small, the state court system has made great strides, though, in many areas over the past few years, and I just want to note a few of these key achievements. At the top of the list is the ambitious KYE Courts Initiative, which has produced e-filing, e-warrants, e-EPOs, new trial and appellate case management systems, and more, in an effort really to move the courts from a paper-based system to an electronic system. I remember addressing this committee and describing the court system as a Gutenberg world in the modern age of Google. And that's kind of where we've tried to bring ourselves into the modern age. We're using technology to improve access to justice and make courts more user-friendly. And a lot of credit for that goes to the General Assembly. We are grateful to the legislature for funding a statewide e-filing program several years ago, and more recently for authorizing $14.7 million in House Bill 556 to facilitate virtual hearings between the county jails and the courts. This infusion of federal rescue funds is also fueling work to expand e-filing, to create self-represented litigant portals and payment kiosks, and develop redaction technology. I've worked for years to bring judicial salaries, branch salaries, up to the level of the other two branches of state government so that our dedicated, non-elected employees can be paid fairly. And we can compete for and retain the high caliber talent that's needed to operate the kind of court system that this Commonwealth deserves. I've also worked to improve compensation for our underpaid elected officials in the judicial branch. Our judges earn over 20% less than the national average, and that continues to be the case. Our circuit court clerks make an average of 11 to 13% less than their counterparts in the very same county in the county clerk's office. We've made another big push for our salary parity plan during this year's budget session. And while the final budget fell short of fully funding our proposed increases, I was very pleased that all non-elected employees off probation received salary increase of $2,000. And 8% for all justices, judges, and circuit court clerks received 8% increase as well. We're grateful for that. I'm grateful for what we've been able to achieve this last session, and I appreciate the legislature's support in improving judicial branch compensation across the board. Any salary increases we can provide to our elected officials and non-elected court personnel are well-deserved and long overdue. And in spite of these gains, I must sound the alarm about the still lagging salaries of Kentucky's judges. Their raises have been exceptionally small and infrequent over the past 20 years. And their salaries remain among the lowest in the country. In some instances, Kentucky ranks below all the states and the territories, save two. And their salaries remain at that level. Inadequate pay is not only disheartening for the current judges, but it's a hindrance to attracting the best and brightest attorneys to leave private practice and enter the public service of the judiciary. In November, nearly every judge in the Commonwealth is on the ballot. And come January, we'll see a huge turnover as these newly elected judges take office. As our judiciary changes and evolves, I encourage the General Assembly to protect the quality and integrity of this extraordinary asset by making improved compensation for judges a top priority in the years ahead. If there is a third rail state politics, and I've described that, used that term with this body before. It's the issue of judicial redistricting. Over several decades, Kentucky's counties saw substantial shifts in population and caseload, while the judicial circuits and districts remained largely untouched. And unlike legislative redistricting, revising judicial boundaries can't be accomplished by simply making changes based on population. Our process is much more difficult because it's based on caseload, not population. And that caseload demands determine the workload of the circuit, family, and district judges. In 2014, the judicial branch took on this immense task at the request of the legislature to produce a judicial workload assessment. The study would measure the time it took to carry out judicial duties in trial courts statewide, and then use that information to develop case weights on which to base a data-driven, equitable distribution plan of the case responsibilities. We were successful with that research, and in 2016, we presented the first statewide judicial redistricting plan to the legislature. And while the effort has been more painful than anyone might have predicted, we've made good progress toward equalizing workloads across the state by reallocating some judicial resources to create new judgeships where they were most desperately needed. Starting in 2023, when the redistricting plan goes into effect, this difficult but necessary task will result in more timely access to justice in several counties in Kentucky, where we've realigned the number of judges to better match the caseloads and demands in those jurisdictions. We've taken several steps to demonstrate our commitment to operating in an ethical and transparent manner and being good stewards of the taxpayer dollars that we're appropriated. The Supreme Court adopted its first open records policy for the administrative records of the courts. We also created the AOC's first internal audit department and audit oversight committee. We now require biennial audits of the court system's financial records, and we have a fraud, waste, and abuse tip line to facilitate complaints against court personnel. We've made our salaries and our contracts and our spending records available to the public on Kentucky's transparency portal. And we created the first Circuit Court Clerk Conduct Commission to investigate and review complaints against circuit clerks, the people who maintain our records for the circuit and district courts. I'm also proud of a wide range of other accomplishments, including our 2014 collaboration with the legislative and executive branches to enact juvenile justice reform, which is improving outcomes for juvenile offenders by reducing detention and increasing access to treatment and to services for those juveniles. In 2010, I created the Kentucky Access to Justice Commission to increase access to civil legal aid for the poor. The Kentucky Access to Justice Commission is also a critical partner in helping us provide innovative self-help resources to those handling legal matters without the assistance of an attorney. We've also changed processes and perspectives to reduce disparities in courts through our Racial, Ethnic, and Equity Disparities Initiative. And we developed our first statewide family court and juvenile court rules of practice and procedure, a move that's helped create uniformity in these important cases. Mr. Chairman, it's been a gratifying and at times tumultuous 14 years, and I appreciate you allowing me this time to spend just a moment further to reflect. Now I briefly want to look ahead at sharing my thoughts on how several current issues will have a growing impact on the future of the judicial branch. The 2020 global protest against systemic racism, sparked by a succession of high-profile police brutality cases involving Black Americans, have highlighted awareness of differential treatment by race and ethnicity and renewed calls to address these inequities in the court system. While the court system has become much more intentional in its approach to these issues, we realize there's much more work that needs to be done. We will need to prioritize resources and training to strengthen our inclusion and diversity efforts in the years ahead. Public institutions face a growing demand for services on digital platforms that are easy to use and easy to access. In addition to our KYE Courts initiative, we've started using text notifications as reminders for court dates and jury service. Our website to provide a wide array of resources in electronic transactions and social media to drive the public to our website. Our technology must continue to evolve to meet the changing needs of the modern society. Substance use and mental health disorders, already prevalent across society, have increased with the chronic stress associated with the COVID-19 pandemic. The number of opioid deaths has tragically increased since the COVID-19 pandemic. The economic uncertainties and racial and social inequities complicate this matter. And we must do more as a court system and as a state to address these issues. In August, we launched the Kentucky Judicial Commission on Mental Health, an ambitious undertaking that has 72 members. We will explore and recommend and implement transformational changes to improve the judicial response to cases involving mental health, substance use, and intellectual disabilities. The fundamental meaning and nature of work is evolving rapidly as a result of digital and augmented intelligence, shifts from physical to virtual workspaces, multi-generational expectations of the work environment and job satisfaction, and the need for new and different skills to accommodate the jobs in the future. So the court system must keep pace with these changes to remain competitive in a challenging job market. Climate change. Who would have thought the Chief Justice would be talking about that? Climate change continues to affect areas such as human health, the quality and quantity of water, energy, transportation, agriculture, forests, and ecosystems. Climate change is also behind more severe and more frequent natural disasters like the tornadoes and flooding our Commonwealth faced last year, snow yesterday in Somerset, right? With time running out, we need to escalate our emergency planning, management planning to reduce future property loss and minimize disruptions in our courts. In closing, Mr. Chairman, I want to acknowledge those whose vision, hard work, and collaboration have made our progress possible. I am deeply grateful to the General Assembly for the valuable partnership that we have nurtured over the 14 years that I've been coming before versions of this committee. Together, we've positioned the court system for a bright and viable future through honest, open communication and a relationship based on mutual trust. And I really say that in most sincerity, Mr. Chairman. Thank you for the role that you have played and others who are sitting before me in making that happen. I also appreciate our many other partners, including the 3 governors under whose leadership I have served as Chief Justice, the state agencies, county and local governments, treatment providers, schools, businesses, community organizations that have all worked alongside us to tackle tough issues and implement solutions to enhance the lives of the people we serve. I've been fortunate to count as colleagues and friends the exceptional justices who sit on the Supreme Court who share my love of the law. And it's been an honor to work with the judges, the circuit court clerks, and court staff who serve every county in the Commonwealth with a deep sense of duty and dedication. I'm privileged to have had a hand in encouraging our court community to find the middle ground as much as possible and to work with them for the preferred outcome. As Eleanor Roosevelt said, for our own success to be real, it must contribute to the success of others. And that, Mr. Chairman, should be the motto of the court system. I also want to acknowledge my wife Susan and our children who have indulged my desire to find professional and personal fulfillment in the public arena of judicial service. They've made a great sacrifice to make my life complete. And finally, as I exit the stage, or rather as I step away from the bench, I want to leave you with a charge as you carry on your important work of governing. I can say with great certainty that the state of the judicial branch in Kentucky is strong, and nothing is more paramount than preserving its independence. The very health of our republic depends on a system of three separate but equal branches of government. I hope that your relationship with my successor is as productive and cordial as the one that I have shared with you, and that the separation of powers remains the basis for every good thing that state government can achieve. I want to thank you again, Mr. Chairman, for making this time available to me, allowing me to share my thoughts with this committee and with through you, with the entire legislative branch. And with that, I conclude my remarks. Thank you.
Thank you, Chief Justice. I do want to open it up for any questions of membership if they have any questions or comments. Senator West.
Thank you, Chief Justice. Good luck on your retirement. You've been a joy to work with, and
Thank you.
and very easy for us to talk to here and communicate with from the legislative side. So good luck in your future endeavors. And
Thank you.
this deals with COVID, future spikes, future events. In your learned opinion, do you feel that Judiciary is ready if we have another COVID event? Is the technology in place? Is the Judiciary ready so we will not see some of the delays we saw in the first round? Criminal trials,
Right.
evictions, those types of things. Are you prepared, you feel?
Well, I think yes, and yes, much better prepared than we
Right.
were before, because literally we formulated our first order as a Supreme Court. First of all, we felt that it was needed for the first time for us to address like the whole system, not just on a county by county basis, and that was a different approach. But we weren't sure. But we thought that first order, this will take, 30 days, 60 days, and things will be back to normal. And we all know that turned out not to be true. So we've learned that. We've also, of course, been able to tool up the use of technology in ways that we'd never thought. And I think we've learned a lot about that and how to make that happen. So I think we're much better positioned, Senator, than we were before. Certainly we are. I can't predict what the future holds, but I do feel that has been a tremendous learning experience and really a changing experience for us. But thank you for that question.
Thank you.
Senator Turner.
Thank you, Mr. Chairman. As a young practicing lawyer, not young in age, but I met you in the 80s in a trial that went on for 2 days with a jury arguing, a big snowstorm and all
Right.
that, and I appreciate
I remember that trial.
that trial and what we went through that time and all the hard work you've done, especially during this COVID time. I do respect that as a practitioner of 40 plus years and seeing the changes in the court system, and hope you a good future out, enjoying the rest of your time with your family and whatever you. I do have one comment though. When I was asked about climate change by a government agency doing things where I'm over in Fleming Neon about the rain, I said, well, if you read the Bible, the rains and the storms came back then, and my great-great-grandmother was born in 1863. She didn't die till 1961, and she told me all about the floods they had then, and there was no such thing was gasoline cars, coal mining, or nothing. And they had them there in the mountains. They'd even wait on the rain so they could flood the rivers would flood to float the logs down the stream. So climate change is a historical thing that I think we need to take a closer look at.
Sure.
Thank you,
Yes,
Mr. Chairman.
thank you, Senator.
Senator Wheeler.
I guess my follow-up be to Senator Turner's comment there. I mean, what role is it of the judiciary to take a stance on climate change? I would think that would fall within the policing powers of the legislature to create energy policy.
Well, if the legislature can control the weather, more power. My statement only has to do with our ability to respond to the emergencies that we see ahead. We had to move pretty quickly, and we need to be prepared for to react to the to things like the situation we had in Hindman. We had to deal with it pretty quickly. The tornadoes in western Kentucky, we had to deal with that quickly. So we need to be prepared both physically and fiscally to respond immediately to keep the courts open when these things happen.
Thank you, Mr. Chairman.
Representative Moser.
Thank you, Mr. Chair. And Chief, it's been such a pleasure to get to know you and to work with you over the past few years that I've been here. And I really, I just want to make a comment about your response to the substance use disorder situation that we find ourselves in, and all of the health issues that we are trying our best to address. And the court system's response really is looking hard at the intersectionality of the court system and treatment for individuals with a substance use disorder or mental health issue or developmental delay or a developmental disability, intellectual disability. The court is oftentimes the first place that these individuals are identified. And so when I came in with my history in healthcare and drug policy, I was keenly aware of this kind of cross-pollination, and I've loved working with my judges in Northern Kentucky, as well as AOC and all of the fine folks here, and especially the Supreme Court, on finding ways to intersect with the individuals who need help. And I just want to really applaud your efforts and congratulate you on finding a way to bring stakeholders together with the Kentucky Judicial Commission on Mental Health. And just to say what a privilege it is to be a part of that, and we will certainly do our best to carry on your legacy in this space. Congratulations on your retirement, on your excellent years of service, and thank you for all you do.
Thank you. Thank you.
I hope we don't, this is not the last time we see you.
Well, I hope not too. I will continue to pay close attention to the work of that commission. The work is huge. We announced that with the understanding the reality that our jails and our prisons are the largest mental health institutions in the Commonwealth, and it needs to be addressed. Thank you, though. We appreciate your membership and participation in that committee.
It's an honor. Thank you.
Senator Berg.
Thank you, Mr. Chairman, and thank you, sir. I unfortunately haven't gotten really to know you because I haven't been here that long, but I just wanted to put in a plug real quickly. 10, 15 years ago when we started doing telehealth at the VA, I thought, oh my God, we've lost our minds. How are we going to take care of people remotely? Mm-hmm. And it has become an absolute godsend to medicine. It has enabled us to reach more people more efficiently and effectively. And I really applaud your plug and our chairman's position that we have a way of actually streamlining and improving services to people in the Commonwealth by utilizing technology in this way. And I just want to say thank you for bringing that up.
Well, thank you, Senator. The availability of telehealth makes our drug court, our treatment courts all over the Commonwealth. It brings resources to places, even though that resource may be physically located many, many miles from the location. The virtual access makes treatment possible. Thank you, Senator.
Representative Flannery.
Chief Justice, I want to comment. Do appreciate the advancements that have been made on e-filing as a practitioner. It has been very helpful. I find it very helpful not only to members of the bar, but parties that are involved in litigation. I think it's just much more efficient. Hopefully, we can improve upon that. I know civil actions, all tort actions, I think, have to be filed November 1st electronically, and hopefully we can take a step even more and try to find ways to utilize Zoom court more uniformly across this state. And I appreciate all your efforts. However, I must say that I find it very concerning that you believe one of the biggest challenges facing the courts of justice is climate change, and that very concerning that you would even insert those comments in this forum. Thank you.
Senator Carroll.
Thank you, Mr. Chairman, and Chief Justice, wish you your retirement. It's been a pleasure working with you, sir. I'm going to put you on the spot a little bit. You spoke a little bit about the balance between the legislative, the executive, and the judicial branch. In recent years, from my perspective and many others in the legislature, there seems to be that often judges are attempting to make law from the bench. We've seen the executive branch overstep in their authority, and we've seen the legislature act on that. And then, as a result, we've seen the executive branch accuse the legislative branch of overstepping their authority. So, not to get into any details, but in general, what advice can you give for us to help us maintain that balance within the Commonwealth, and to ensure that we're able to keep that, and that political motives don't overcome what the purpose of each branch is for in maintaining the integrity of each branch. And we've seen that in question in many times over the past few years. Yeah. Could you comment on that, please, sir?
I appreciate the question, even though it is a complicated question, and the sincerity with which you've asked me that question, because I know you're sincerely looking for the answer. The way we're built, and this has been said over and over, the way we're built with three separate branches and strong commitment to the separation of powers in those branches, has been said many times, is not built for our comfort. It really is a discomfort. It's built for tension built into the system, and those tensions have played out in the last few years of my tenure on the court more than I think. I really haven't gauged it. It just feels like there's been more of that litigated in the last decade or less than ever before. I don't know if that's the case. I've not studied that, but it's felt that way. So I understand what you're saying, as each branch is trying to find its way. And for us to, I'm not sure what I can suggest is the magic way for each of us to recognize what is our lane and stay in it. But that's the concern. How do we do that? And it's been often the rule of the courts to be the final arbiter of those kind of questions, and that puts us crossways most of the time with one or other or both of the other branches, and that uncomfortable tension is built in. And as I suggested, to maintain the independence of all three branches is critical to the success of our republic, I think. That's not answering your question. We could spend a college course.
I have no doubt.
This gives us something to do in retirement, Senator. I can contemplate that. Thank you.
Thank you, Chief Justice. Thank you, Mr. Chairman.
Representative Nemes.
Thank you. Mr. Chief Justice, appreciate your service and look forward to working with you, continue to work with you even in your retirement. I have a question now that you've been on the trial bench for a long time, a Court of Appeals bench, Supreme Court and Chief Justice for the last 14 years or so.
14.
So my question is about the structure of the courts. One of the things that I strongly oppose is judicial elections. I introduced a bill a number of years ago to get rid of judicial elections. I think it's not the way to go. I think judicial appointments are better to preserve the integrity of the judiciary and to make sure that we're not getting Democrats or Republicans as partisans on the court. Not asking for your comment on that particular unless you want to, but my question to you is, if you were able to make one structural change to the judiciary, what would it be?
Well, I already talked about raises, right? That's again the you and Senator Carroll and I would the college class. You know, I would comment on. I guess begin my comment by observing, as I've said to you all before, Kentucky. With the adoption of the judicial article, and I know you're very familiar with that process. You know, it was a legislative effort that became a constitutional amendment that became the law, but it was an incredible overhaul of the historic court system in Kentucky. We went from a county-based system to a unified court system, and we're not unique, but there are only a small handful of systems here, and it's different from any of our surrounding states. We are the only unified system. Maybe Missouri has a similar system, but they still have local courts. But the courage and the foresight and the wisdom, of the 70s that brought about. It didn't bring about the appointment of judges, as was part of that consideration. That was rejected over the idea of electing judges. But I think we have, over the past 40 years that we've been in 40 plus years we've been in existence, been learning what it means to live into this idea of a unified court system and all of the things that means. And so I don't know that this doesn't address your specific question about the structure of the judiciary, but I would say that learning more and more how to better serve the public as a unified court system is a challenge that we've not yet fully accomplished. And I think that's something that's a work in progress, and it's an interesting work in progress as to how we continue to grow and evolve in that way, to be of better service as a court system.
Mr. Chairman, a quick comment.
Yes, sir.
Well, thank you for that. I agree with you. I want to highlight something that you said, and that is the unified court system that we passed in 1976. I also practiced law in Indiana, and the system there is much different. It's not unified. Right. It's dispersed, and I want to impress upon the people of Kentucky, and especially the people in the House of Representatives. We have very few attorneys in the legislature. Our court system in Kentucky is an absolute gem. We get frustrated by separations of powers issues. Nobody more than me. We all do.
Right.
But our court system structure is really good. I do think we need to get rid of judicial elections and appellate judges, but our structure in Kentucky is far and away above most judicial structures across the country. And so, anyway, thank you for your service, and look forward to working with you even after retirement. Thank you. Thank you, Mr. Chairman.
Senator Nemes. Mr. Chairman.
Chairman Massey.
Thank you, Chief Justice. How are you?
I'm well. How are you?
I listened to you on the way in because I had to take care of some matters this morning. But I want to tell you that it's been a pleasure to work with you. The difference between us is you're leaving voluntarily and I'm not. But that is what it is. And but you've been not only a great friend here to the legislature, you've been a personal friend, and because of you, I'm now licensed in the state of Wisconsin, which I appreciate. You swore me in over the phone, right, but it was nonetheless appropriate. So we've been through a lot of different matters together. We've been through the changing of the different family courts, and we've been through some discussions about where cases should be heard, et cetera. And even though we've had some battles at times, to be honest, you've always been very professional in that engagement, and I very much appreciate that. That's what I've always, that's what I dreamed about when I went to law school. That's what I learned about in law school. That's what I've practiced in many professionals, because the civility in many ways has been lost in our society. I've not only seen it in the Capitol, I've seen it in the courtrooms. I've seen it between practitioners and lawyers. It's different today than even when I first started, and I think we need to return to some of that civility, that professional decorum that allows us to get something done rather than just having a chaos all the time. So I appreciate your endeavors to make that happen. I'm very appreciative of that, and I certainly wish you the best. Maybe we can go fishing together, since I won't be here either, but we'll see what happens. Thanks.
Thank you, Chairman Massey. I do want to say I'm a product, I guess, of another era in terms of the law practice. I give credit to having been a product of the Bowling Green Warren County Bar, where I was trained by my mentors to to respect your opponent on the other side. To if you say you're going to do something, you do it. If you make an agreement, if you need, you accommodate each other. And the practice of law was much more pleasant and workable in that sort of environment. That's the environment in which I was raised, and I would like to think I have encouraged others that when I speak to the young lawyers, I say to you, your integrity is the most important thing that you have. You try to cultivate that and you guard that throughout your professional career. And so I thank you, Representative Massey, because that's the kind of relationship that you and I have had. Thank you.
Representative Bratcher.
Thank you, Mr. Chairman and Chief Justice. Every time that you've come before this committee, I've asked you the same question, and I'm still not satisfied. And I've asked almost every lawyer friend I know of why it takes so long for some of these decisions. And I'm talking from district court, where I can give you a neighborhood issue that just took 2 years. I think it was a circuit or district court level. And I would ask friends in the appeals, I guess I can name his name because he's retired now, Irv Mays, and he said that's just the way it's always been. And then some have said that you guys, your workload is so burdensome that it just takes 2 years to say, finally come up with a decision on House Bill 563, which I think you're getting ready to do. I believe that was passed 18 months or plus ago. Why does it take so doggone long for you guys to make a decision?
I'm going to try to answer that quickly. You know, it's always been a criticism. When I went to Judicial College back in 30 plus years ago, the criticism of the court system was it costs too much, it takes too long, and it's never over. And that continues to be the question you say you've asked me every time I've come before. Why is it that way? We're doing, we're trying as best we can, at least administratively here, to address that with adding opportunities for efficiency. The decision-making process is inefficient in and of itself, with two sides disputing, two sides feeling strongly about issues. And as a judge, you want to make sure you've heard it all and you've read the law and you understand it. So it does take time. It shouldn't take so long. I agree with that.
Representative Petrie.
Thank you, Mr. Chairman. I've practiced in front of you way back when.
Yeah.
Interacted with you through the Judiciary Committee and interacted with you in Appropriations and Revenue. And we have our disagreements. We have some that are vehement, some that are minor, and we have a lot of agreements. In each of those three contexts, we've had those. I simply want to tell you, though, thank you for your public service. It's not easy, and every time I've interacted with you in each of the easy and difficult issues, you've always been consistently professional, showed integrity, and did what public servants should do. Think through things.
Thank you.
Disagree and agree when you need to, and keep moving. And I wish you the best. Thank you.
Thank you very much.
Chief Justice, when I first got this job, Roberta's predecessor, a couple of Robertas ago, John Great, suggested, and I didn't know who John Great was. Everybody in here knows who John Great is. Yeah. I didn't know who John Great was at the time, but he suggested, hey, you ought to have a day when you come up and meet all the folks that are related to the Judiciary Committee and the work. And I was as clueless as I probably sounded and looked to everybody else in the room. And we had a day met over at the Capitol, and then I had a meeting early on with you in my office in this building. And I still remember it vividly. I don't remember any other first meetings like that, but I remember the meeting with you vividly. And I thought to myself, what kind of an idiot am I that I managed to find myself in this spot as this chair speaking with the Chief Justice of the Kentucky Supreme Court? And I felt then terribly out of my depth and unqualified to be there. I still feel a smidge of that today because you are a fantastic justice and a bright legal mind, and you have a reputation for your dedication to public service for sure, and you've heard that spoken to already by my colleagues. But you are well regarded in the Commonwealth, and you are well regarded around the country. Now, I've met your counterparts, a number of your counterparts around the country, and members of the courts in various places around the country, and they all know who Justice Minton is, Chief Justice Minton is. It's a respect that's been well earned, and I'm gonna be sad to see you go. I feel that we've always gotten very much along, and I think, regardless of how you rule or how I legislate, I think our relationship has always been very positive, and I have found it very rewarding, personally and professionally. And it's a much you've dealt with all kinds of people in positions of influence and significance, and I'm just a peon in the mix. But I get to consult and confer with the Chief Justice of a Supreme Court, and that's no small thing. And it's a feather in my cap, and I'm honored to be able to do it. The work of this committee is the most important, or among the most important things that I do in this job. And as an attorney and as a former prosecutor and continuing a practitioner in the courts, the work of the court system is always near to my heart, and it's something I think about quite a lot. And so I'm glad to have you here before this body, and I'm glad that you've always been accessible to each of us, all of us, not just the chair of either chamber's committee. But I'm thankful for you, and I'm thankful for your service. And I won't look at a bottle of honey or see a beehive without thinking about what you're going to be doing in retirement as the apiarist with the coolest job resume I've ever seen. And I'm thankful for your service as well to the people of Kentucky. Class act to thank your wife and your children for that. I hope I remember to thank Amanda when my time comes to leave, and my kids, because they, just like everybody else's family here, it is a big sacrifice. Yeah. I'm thankful. Thank you for your service, and thank you for being here and presenting one last time before this august body about your work in the court system. With that,
thank you, Mr. Chairman.
Thank you. Thank you. Representative Nemes reminded me, and I see just over your shoulder that Deputy Chief Justice Hughes is with you. And I should have recognized you before, or recognized your being in here before, but I didn't. We're glad to have you. Thankful for your service. Your reputation is also sterling, and you also are retiring, if I'm not mistaken. I don't know if you're going to keep bees.
I just like John's honey. It's very good. If you haven't had any, get
Are you?
in line.
Are you going to return back to what is now the 3rd Senate District, your home roots in Caldwell County?
No, I love Western Kentucky. It'll always be in my heart, but I'm a Louisvillian now.
Very good. Thank you, Deputy Chief Justice Hughes, for your service, and thank you for being here this morning. Thank you all. I appreciate it.
Thank you.
We have a quorum. I'm going to go ahead while we're changing out folks. And Senator Mills, you can come on up with your, and Representative Dixon, you can come on up with your folks. I want to go ahead and take a motion on the minutes. I heard a motion and a second, and I think from Representative Fisher and Nemes. All those, any questions, comments, disputes? Thank you, Senator Kerr. All those in favor of approving the minutes, please vote by saying aye. Aye. Those opposed, minutes are approved. I'm gonna let the room clear for just a second. I thought for sure they were all here to hear you guys.
I did too. I'm just...
Anybody else need to answer the roll before we move along? Cool. Your presence is noted and registered. All right. Senator Mills, Representative Dixon, you have the floor.
Thank you, Mr. Chairman, and committee for giving us a little bit of time during the interim. And I apologize for my hoarse voice. I'm campaigning, but that's not why. I hadn't been yelling at anybody. But we have a bill that we'd like to put before you and just kind of vet it and get some feedback on it. But we'd like to comment on it just 10, 15 minutes here, 12 minutes or whatever. BR 161 creates a new section in KRS 508 which deals with assault and related offenses. BR 161 is focused on the act of hazing. Currently, hazing is addressed only in one part of Kentucky law. KRS 164.375 places the burden on universities and colleges to enact anti-hazing policies. The penalties for hazing are to include expulsion or suspension of a student. If an organization sponsors hazing, it may be expelled from operating on campus. These hazing policies are currently in effect at all of our universities and colleges in the Commonwealth. We believe that intentional, wanton, and reckless participation in the act of hazing needs to be stopped in Kentucky. And the only way for organizations and people who operate these organizations to understand the severity of hazing is to attach a crime to this behavior in Kentucky. 13 states have laws that make hazing a felony when resulting in death or serious physical injury. Florida, Texas, California, Utah, Wisconsin, Michigan, Indiana, Illinois, Missouri, West Virginia, Pennsylvania, Louisiana, and New Jersey. BR 161 seeks to add Kentucky to this list of states where hazing activities are frowned upon and whose penal code backs this up with severe consequences and punishments. Ladies and gentlemen, I believe you had the draft of the bill. It's on there. It's in your meeting documents, but the bill is very simple. Section 1 defines hazing and who a student and an organization is. Section 2 sets out that intentional and wanton participation in hazing that results in serious physical injury or death to a student is hazing in the first degree and is a Class D felony. Section 3 sets out that reckless participation in hazing shall be considered hazing in the second degree and is a Class A misdemeanor. In both Section 2 and 3, it states that it shall not be a defense if consent of the student was obtained or conduct was approved by an organization. Once again, we believe that the activity of hazing is not something that we should turn a blind eye to because it can lead to death, injury, and destruction of Kentucky families and friends. So, ladies and gentlemen, today I have with us two personal friends, Tracy and Kirk Hazelwood, and Tracy is going to tell her story about her son, Lofton. Tracy.
Thank you and good morning. My name is Tracy Hazelwood, and this is my husband, Kirk, and this is my daughter, Preston. First and foremost, we want to thank you for this opportunity to speak on a subject that is so passionate about, that we are so passionate about. We are here today to present an anti-hazing bill that will be named after my son as Lofton's Law. Thomas Lofton Hazelwood is the youngest of our 4 children. Lofton has 3 older sisters, so yes, he definitely was the baby of the family. Lofton's 2 older sisters had graduated from the University of Kentucky. The youngest sister is only 17 months older than he, and she stayed home her freshman year because of COVID and virtual classes. So she went to the community college in our hometown. They both wanted to go to the University of Kentucky like their sisters, so the next year we sent two at once to the school in Lexington. Lofton had spent as much time as he could working for a local farmer. He instantly fell in love with farming. That first summer, he learned so much. Lofton was pursuing a degree in agriculture economics. Lofton had signed up over the summer to rush fraternities. He started getting friend requests and invites to different events immediately. His sisters had been in sororities, and we all encouraged him to go through Rush. We believed it would be a good thing. We thought it was a good way to get involved at school, make forever friends, and make contacts all over the country. Lofton started Rush pretty much as soon as he got to school. He called me one day after he had met a group of guys from the farmhouse fraternity. He told me that he'd met these guys and that they were awesome, and he already knew that that's where he wanted to be. They had shared stories about hunting and fishing and some YouTubes that they had watched about duck hunting. He said he was hook, line, and sinker. That's where he wanted to be. On September the 11th, 2021, Lofton received his bid card for the farmhouse. Basically, the hazing started on this day. Upon receiving his bid card that day, he had to chug a Four Loko drink. I'd never even heard of a Four Loko. So I looked it up. A Four Loko is a 23-ounce drink that has 14% alcohol. Then there were different activities throughout the next few weeks. The actives told them that they were going on a camping trip. They dropped them off in the middle of a cornfield about an hour and a half out of town. They took all their phones and they left them in the night. Then they had them vandalize some properties. They spray painted some buildings. Then they had to chew tobacco and not spit until they vomited. Then they had to report to the house super early in the mornings to do wall sits while they were verbally abused. Can you imagine how I felt as a mother? Lofton had called me and texted me a few times that he wanted to drop out of pledging. My husband and I were both so adamant that he was not dropping. We truly thought that he was just being a baby. He was the baby of the family. That he told me he couldn't stand the way that they talked to him, but we had no clue what he was going through. We told him it was almost over. On October the 18th, 2021, 5 weeks into pledging, Lofton passed away at the farmhouse. He started this day off by going to class. I talked to him that morning before class. After classes, he called his sister Preston, and they went to lunch. After lunch, she went to the library, and he said he was going back to his dorm to do some homework. Lofton had a meeting at 4 o'clock that night. He headed to his meeting while talking to his best friend back home on the phone till he was literally walking in the door at the farmhouse. Lofton was stone sober. That was at 4 o'clock. They were supposed to go serenading that night to the sororities. We were told that it was a tradition for them to drink Wild Turkey 101 before they serenade to give them liquid courage. It was reported that he had about 18 pours in a solo cup. At 4:50, he was so intoxicated that he could barely walk, and they ended up practically carrying him to a bedroom at the house. They laid him on a bed and took Snapchat pictures of him while they messed with his arms and his body. At 5 o'clock, they all left to go serenading. Somewhere close to 6 o'clock, an active member came home to the farmhouse after he had had a class. He saw Lofton and went in the room to check on him. He was unresponsive. They called for help, but it was too late. I promise you all this is not a call you want to receive. Hazing is out of control throughout this country. The definition of hazing is humiliation and sometimes dangerous initiation rituals, especially imposed on college students seeking membership to a fraternity or a sorority. Lofton's blood alcohol level was 0.354. This is not any form of brotherhood. You should never leave a brother. I looked up the definition of brotherhood. A brotherhood gives you perspective about what is important in life, further enhancing everything you learned growing up. When you are part of a brotherhood, you learn from fellow men about how a man should lead, how they should date, prepare for the future, family, and even advance in his career and financial life. There have been more than 76 deaths of hazing since 2004. 50 of those involved alcohol. I can't understand the fascination of watching your brother get so intoxicated that they can't function or watch them get sick. This is just a few of the incidents around this country. Adam Oakes, he was from Virginia Commonwealth University. His very first pledge incident, he had a .419 alcohol level. Max Gruber was at LSU. They called it Bible study. He drank 190 proof alcohol, and his blood alcohol level was .495. He died in the middle of the night. They waited till the next morning and took him to the hospital after they cleaned him up. Stone Foltz, Bowling Green University, .394 blood alcohol. Danny Santelli, University of Mizzou, blood alcohol of .486. Danny didn't die. His mother is now his full-time caretaker. They dropped him on his head while he was severely intoxicated. He is now brain damaged, blind, and confined to a wheelchair. Timothy Piazza, he was at Penn State. He was severely intoxicated. He fell down the stairs and they just all stepped over him. They eventually put him to bed. His brain swelled so bad it cracked his skull. This has got to stop. Chances are several of you here today in this room were hazed in a fraternity. You've done things that you've probably never told anybody. Kentucky needs a law against hazing. Our hope for this law to pass, our hope for this is for this law to pass and deter these fraternity members from hazing. It needs to be a misdemeanor and a felony for physical bodily damage and death. Since Lofton's death, we have heard so many horror stories from parents whose children, they actually made it. No parent should ever have to go and experience what we have experienced with our son Lofton. He was a baby brother. He was our son, a grandson, a nephew, a cousin, and a friend to all ages. Anybody that met Lofton were instantly drawn to him. I made a promise to him that I would do everything in my power to stop these senseless acts. My youngest daughter and I have been visiting high schools throughout our area talking to seniors about hazing and alcohol and not leaving your friends. You've got to make that call. Don't be scared to call. I believe in my heart that if somebody had stayed with Lofton that night, he'd still be here today. Upon closing today, I beg that you please consider this bill. We need Lofton's law in place as soon as possible. It's not going to bring my son back, but it might save somebody else's son. Don't think that those things won't happen to you, because they can. Thank you.
Thank you, Mr. Chairman. Jonathan Dixon, District 11. Lofton Hazelwood's untimely passing has hit my community of Henderson in a very difficult way, as you can only imagine. This unfortunate event has raised concerns about our youth in college and the acts that they are performing while they are not in class. In my opinion, fraternities and sorority organizations are great ways to enjoy and experience college. They are very beneficial to many students in their college life and after college. But I hope by starting this conversation today about the risk and the potential outcomes that have come from hazing, we can potentially add a stiffer penalty to those who engage in that behavior and result in saving many, many lives. Mr. Chairman, thank you for allowing us to present today. We would be happy to take any questions.
Thank you. Thank you both, gentlemen. Thank you, ma'am. for your story and for coming to share with us this morning or this afternoon. There are a couple of questions. Representative Blanton.
Thank you, Mr. Chairman. First of all, thank you to the Lofton family for coming, telling us your story. My sincere condolences. My questions is for the senator and the representative, not trying to derail by any means what you're trying to accomplish here, but I have concerns with the verbiage. One, and I know typically we tend to revert back to other statutes for definitions of what serious physical injury is. I think it would be nice to at least refer you to the statute that you're using the definition in this statute, or lay it out within the statute itself. Secondly, I think your intent is to cover these groups within the schools, like fraternities and so forth, for those protection. But I noticed for the under Section 3 that you provide a defense for athletic competition events, law enforcement training, or military training. I would like to see something along those lines in the first one as well, not so much for the athletic, but the military and the law enforcement training. My actual reading of your definition here of hazing, it's just not clear whether or not this could pertain to law enforcement training and or military training. We all have learned that our intent may be one thing, but the courts may interpret that differently. So we want to be very crystal clear, because some of the things you talk about is elements of the weather. We even have ROTC in our high schools and our colleges that sometimes they go out on maneuvers and different things where elements they could be exposed to as part of training. It's not necessarily intended as hazing. Same thing for law enforcement. So I just want to make sure we don't get them caught up in what you're trying to do. I'm not trying to prevent you from what you're trying to accomplish. I just want to make sure we're crystal clear in what you're looking to accomplish and that it applies to those specific groups.
Very good. Thank you, Representative Blanton. Those are the exact comments that we were looking for today, to be quite honest with you. So we will incorporate that in, and we will run it by you to make sure that those are clear for you.
Thank you, Mr. Chairman.
Representative Flannery.
Thank you, Mr. Chairman. First, to the Lofton family, I was unaware of this event, and I know it's probably very difficult for you to come and share what has happened to your family. But it's very important as policymakers to hear these stories even when they are difficult to tell, so we can react in a responsible way and try to craft policy and make changes to our law to hopefully prevent this from happening again. Senator Mills, Representative Dixon, appreciate you all advocating for this family. I guess one comment or maybe a suggestion on what I personally think, just one lawyer's take on this, and a former prosecutor. I think most of this type of behavior could fall under assault and most likely would fall under wanton endangerment. Maybe there's some changes that need to be made. I guess one suggestion I would have is to, if you really want to prevent, maybe we need to consider enhancing this to a Class C felony potentially, or just find ways to be more punitive to discourage this type of criminal behavior, or maybe even have some sort of aggravated offense if it involves some sort of sorority or fraternity hazing practice. But be glad to talk to you all about that. But I do appreciate you all bringing this, at least to my attention. I was unaware of this story, and it's an important story to tell, so we can hopefully this won't happen to any more Kentucky families. Thank you.
Representative Heverin.
Thank you. I will be brief. I just want to thank the family. I keep thinking of the quote, growing old is a privilege denied to many. And so I thank you for your courage today to come and to speak about your son's story and turning your pain into helping others, other families not having to go through that. You have got a great representative and a great senator on your side to advocate for you. And, so many times we see legislation as just small changes, but this is a real game changer for a lot of people. And so I just can't thank you enough. I know it's very hard for you all to be here today to share this and to be so vulnerable in front of a group of people across the state. And so thank you all for what you're doing. And I look forward to helping you all get this across the finish line into the governor's desk during the 2023 session in honor of your son.
Senator Byrd.
Thank you, Mr. Chairman, and thank you to you and your entire family for having the courage to come up here and speak about that. This is not easy. My question is probably not for the family. What happened at the university? Was the fraternity immediately disbanded and is no longer allowed to be a fraternity on campus?
Yes. For simpler words, they were kicked off immediately. I mean, they had to shut everything down at the farmhouse. Actually, it wasn't completely. At Christmas, I guess they emptied out the farmhouse and everything was gone. It's been sold.
Okay, so the fraternity is no longer allowed.
They're not
on
supposed to
campus.
have any kind of association with any of the old pledges or anything.
Yep. I think according to the university policy, they have 7 years before they can apply to come back on campus. That's kind of similar across the state.
And were there any other legal options taken against the fraternity?
Yeah, there is a pending
lawsuit. So this legislation would basically help making the individual students more responsible for their behavior, but would in no way excuse the institution of their responsibilities, which, ideally, alcohol is not allowed in fraternities on campuses under any circumstances. So this would just enhance the responsibility of the individual students. Thank you.
If they think that it could be a felony against somebody, I think it would deter them from doing the things they've been doing.
Did you feel, can I ask a follow-up?
Yes, ma'am.
Did you feel, and you may not be aware because your child was away at school and, you may not have had these discussions. Did you feel or were you aware of any efforts before this happened to make sure that the people who were running this hazing were aware unequivocally that what they were doing was illegal and should not have been allowed to continue?
We didn't know what was going on. Yeah. Like I said before, he had told us he wanted to quit, but he was the baby of our family, and he would tell me he didn't like the way they talked to him and things like that, but we didn't know half of what was going on, not even a fraction of what was going on.
Representative Bratcher.
Well, thank you, Chairman. I think my question was just answered by Senator Byrd, because I know at U of L there's no alcohol. They went through all this, and so there's no alcohol in any fraternity in Kentucky. Is that currently the situation?
I do not know that for a fact, Representative Bratcher, but I believe it's discouraged.
So these fellows, this fraternity was blatantly going against school policy, and you want a consequence to that if it ever happens again. Is that where we're at? Okay, thank you.
Senator Kerr.
Thank you, Mr. Chairman, and I too want to thank you for coming today. This is very, very important, and I just can't imagine how difficult it is in the post-traumatic stress that it causes for you to come, but it's important. And as this bill moves forward, and I have a really good feeling that it will, I hope that you can keep on keeping on, and it is important, I know, for your Lofton. I too would be in agreement that the penalty should be as tough as you can make it, Mr. Chairman and Mr. Sponsor. I guess I'm wondering too, would it be possible, or have you all considered, and I know that's part of why you're here today, Senator Mills, putting in an educational component or some kind of component into this that trains these other fraternities or these other student organizations on what this is, the law, and the consequences if not abided by.
I think that's a great idea. I know my son was the president of his fraternity. He was a KA. He went to South Carolina, had national training. This subject is broached, but once again, there needs to be a penalty that holds people accountable to make sure that, it's more than just continuing education, that it's real.
Mm-hmm.
So, thank you, Senator Kerr.
Representative Decker.
Thank you, Mr. Chairman. Just a couple of comments. I too thank you. I think this is the second time since I've been in the legislature that I really was brought to tears, and just it is hideous what has happened to you. I can't fathom it, and it takes great courage for you to come and talk about it. Thank you very much. A couple of comments about what you're proposing, and I look forward to studying it in more depth. One thing I worry about in the legislature is when we pass bills that already are in existence in other ways in the law, just as Representative Flannery talked about, there are criminal penalties for this type of behavior, and there is civil court. So I look forward to seeing what you're proposing and how it's different than other laws. I do like the thought of education, but I just wanted to go back a little in history. When I was in college, this happened, and my husband's fraternity at one point was kicked off campus, and he thought it was the right thing to do. This isn't new, and you know that. But there are campus rules against this. There's campus training. When my son was in college, his fraternity was kicked off campus. He had already moved out because of the shenanigans and the reckless behavior. So the colleges do have stringent rules about this. There are laws that can be used. So I just want to look deeper at what it is you're proposing, because if there are rules and laws that could be enforced now, they should be, and perhaps the education is with the prosecutors. So thank you very much, and I look forward to looking at the bill. It is an important issue. It needs to stop. Over the decades, it's needed to stop. So thank you for your testimony, and thank you for the bill, to the bill sponsors.
Mr. and Ms. Hazelwood, thank you. Thanks for sharing your story again, and thank you for coming here. I know it's difficult. I can't imagine how difficult it is, and I don't want to, but I'm thankful that you're doing it. And I'm glad that Senator Mills and Representative Dixon can bring the bill forward for us today to get the kind of comment and feedback that they've asked for and that they wanted ahead of the 23 session. So thank you all very much. Be safe getting home. Okay. Now, Dallas, I don't know who's coming up now. I've gotten text messages. Whoever wants to come on up and talk about this, come on up. Okay. You all will no doubt remember Representative Adam Bowling's bill, which I believe was House Bill 7, to create the Recovery Ready Communities Act and that program. And I invited a lot of familiar faces up to speak about that to us this morning or this afternoon. And I know who you all are, but if you would give your names, and you have the floor. And you have 33 minutes.
Chairman,
Chairman Westerfield, Chairman Massey, members of the committee, my name is Van Ingram. I'm Director of the Kentucky Office of Drug Control Policy. With me is Pam Darnell, who's the chair of our Recovery Ready Advisory Council, and Dallas Hurley, who should be no stranger to this committee.
I'm sorry. What was that name? One more. I can't ever seem
Hurley. November 1st, I'll celebrate 18 years with the Office of Drug Control Policy, and during that time, I've worked on lots of pieces of legislation, but none has been more fun and none has been more exciting than House Bill 7 in the 21 session, sponsored by Representative Bowling, signed into law by the Governor Bashir. It has been a lot of fun to work on, and we're getting close to the finish line. The bill sets up a council of people who are really representative of Kentucky. We've got representatives from the League of Cities, from the Kentucky Association of Counties, from the Chamber. We have people who are in recovery. We have people that work in the treatment field, law enforcement. Very inclusive committee. Representative Bowling really did his homework when we put this together. And so after the commission got appointed, we spent some time meeting on Zoom to educate the committee about what's already going on in Kentucky as it relates to recovery and it relates to substance abuse treatment, and as well as prevention and other programs. Really trying to get the feel for the lay of the land, what's going on in the state, and what communities need to have, what communities need to be thinking about. It won't be long, many of our communities, about 90 of them, will be coming into some opioid abatement money. And we spent some time talking to the League of Cities. We did a presentation up there. We're going to do one at KCO in November. Because we really got a once-in-a-lifetime opportunity here for communities. This money's not going to come back around. And I really am encouraging communities to take stock of what they have as it relates to recovery, but more importantly, to take stock of what they don't have. We've been working on the Opioid Abatement Commission. We've been traveling the state. We've been to Pikeville and Hazard and Ashland, and Tuesday we were in Covington. And it's like Groundhog Day. The issues are the same. Transportation, transitional housing, child care issues, no matter where we go. And I think when we're in Lexington next week, we'll hear similar stories. So this bill couldn't be more timely as it relates to those funds. And the Office of Drug Control Policy has really enjoyed working on this. My staff has. They get excited about a new project like this, not like this is something else we have to do. They are excited to work on it. But Office of Drug Control Policy is a small office, so we contracted with the Volunteers of America Mid-States to help us develop the protocol for recovery-ready communities, to go out and educate cities and counties about what it takes to be a recovery-ready community, and then to certify communities as doing that as they apply, and create an application process and a certification process. Volunteers of America Mid-States has been a partner for us on other projects, so we felt comfortable with them. And they had the good foresight to go out and hire a young man that I met when he was an intern attending Morehead State University and interning to this committee. He showed a keen interest in drug policy then as a 21-year-old and does to this day. We've had many conversations. We've worked on many bills together and really excited to have him on this project. The governor appointed Pam Darnell as our chair. She has been great to work with. The whole committee has been great to work with. But Pam has been a great chair, and I want to turn it over to her for some remarks.
Thank you, Van. I'm Pam Darnell, President and CEO of Family and Children's Place, and thank you all so much for a few minutes to talk with you all today about this incredibly important work. As the CEO of Family and Children's Place, I have seen firsthand the need for communities to develop local strategic responses to substance use disorder. Our families and children are facing an unprecedented crisis in terms of overdose deaths, children in foster care, and lagging workforce participation. We know that in the 2021 annual report of the Child Fatality and Near Fatality External Review Panel, that substance misuse in the home was a factor in almost half of the child fatality and near fatality cases that panel reviewed. We also know that substance misuse in the home, where children are present, create a greater risk of child abuse and neglect. And I want to thank this body for taking decisive action in passing House Bill 7 in the 2021 regular session. And we are at a pivotal juncture in our fight against substance use disorder. There will be $478 million in the opioid abatement funding that will be made available to communities across the Commonwealth in the coming years. And it is very unlikely that we will ever have another opportunity with this amount of funding infusion for us to use. And so therefore it is imperative that communities be empowered so they can make investments in the prevention, the treatment, and the recovery supports that they want using some of these abatement funds. The Recovery Ready Communities Advisory Council's role is to develop a certification that will be used across the state. And the Advisory Council is working hard to assure that the criteria of that certification includes evidence-based practices and interventions that are really geared toward establishing new and supporting existing local recovery-oriented systems of care, and to increase the recovery capital of individuals, families, and communities. The criteria will also encourage adoption of services and interventions already existing in other communities that are proven to be easily accessible and proven to be effective. We know that there is no one perfect road to recovery on the individual basis, and we also know there is no one pathway that is perfect to building recovery communities. That is why that the Advisory Council is helping to build a flexible framework so that communities can pursue the proven strategies that work best for them. I look forward to continuing working with Executive Director Ingram, not only to make sure that this program is successful, but that it is a national model as well. Thank you.
Thank you. I wanted to just reiterate, we are at such a pivotal time where we have three major opportunities to really get a lot of synergy and really focus on this most pernicious public health and safety issues. And I think that's the convergence of recovery-ready communities, Opioid Abatement Commission, and then also the Senate Bill 90 pilot projects. I really think that if, in conjunction with each other and working together hand in hand, I think we can make a big impact. And I really, really, we just can't afford to lose another 2,200 people, both friends, family members, neighbors. It's just absolutely vital that we empower communities to really step up and be able to respond. And just since I've been hired on August 8th and been able to do sort of a breakneck tour across the Commonwealth to see what's working and to get as much input as we could from community stakeholders, it's amazing. It's really heartening. In these hyper-polarized times, we've got, some avid community activists and police chiefs together in the same room coming up with solutions. There is no, we're one team. We're trying to protect each other, and it's very heartening and wonderful. To that, I wanted to sort of share with you today the sort of where we're at. So these were the goals that we proposed to the council itself. Big issue that's still out there, which is a lot of us that live and breathe this can't sort of maybe forget, but it's stigma. And really the stigma of not having recovery be the expected outcome. And we really need to change that. I've had the distinct honor and privilege with working with folks that are in long-term recovery, and they said that, if everyone was given the breaks that I was given, if they were given the support that I was given, I'm not special. They could be me. And so it's really what this project is really looking at doing is creating those protective webs around peoples and communities and increasing that recovery capital. And like what Chair Darnell said, strengthen and develop the recovery-oriented systems of care. And then hopefully our objectives are decreased overdose deaths, increased workforce participation, and then healthier and safer communities for all of us. So I wanted, since August 8th, since I joined the team, this is where we've been. We had 29 separate stakeholder meetings with 18 providers, 13 government officials, over 60 public health officials, and then 49 community members. And those represent all 120 counties. We tried to get as far as we could.
You did not just meet along the I-65 or 75 corridor.
Correct. No, we were very cognizant of that. We know that this looks different in every community, and that and again, there's no one size fits all. This isn't supposed to be a fiat from Frankfurt. This is supposed to be a flexible framework that empowers our cities and counties. And yeah, we took that to heart. We did not want it to be some rigid structure. So I wanted to give a brief overview of how we think this process is going to go moving forward once we get the website and the portal, the application portal, up and running. My team will be engaged in community education and recruitment, and that was one of my asks for you today would be to go back and talk to your county judge executives, your magistrates, and your mayors and council members, and sort of maybe prime the pump and ask them to look into our program and look into participating, because we would love all the support we can find. So community makes their application. We review, the VOA team will review that application, then we'll do a site visit, and after that site visit, we'll make an assessment to the board, and then let the board make their decision. Once we know what the board's decision is, we go to go back to the community. Hopefully it's good news, and if it's not, if it's a work in progress, then we dedicate ourselves to providing any kind of technical assistance that the community may need in order to get to address whatever shortcomings they have in any of the three categories that we're going to be talking about. And then also, that's not on this page, but we're thinking, it's up to the committee or to the advisory council, but we're looking at a recertification process, sort of much like what they do with like police departments, maybe every 5 years, something that's workable, but that still keeps this at the forefront of communities, and they want to keep that certification. So these were the criteria categories, and these are like sort of broadly how we were trying to break down what we're looking at. So we've got prevention, and that could be primary or targeted prevention. We've got some great regional prevention programs. So really, how do we help make sure that the locals are plugged in with those efforts, and then strengthening those efforts. Obviously, access to quality treatment. Now, one thing in terms of like not penalizing smaller communities, and I think I want to give a shout out to the council. I think they were very adamant. They aren't going to hold it against a small community that they don't have a brick and mortar treatment facility, as long as they're working to provide meaningful access. And I think that's sort of the best approach. It's instead of trying to duplicate efforts or that ultimately won't help us, I think it's better to have a strategic viewpoint of how do we get people to where they need to be. So that was good. And then in terms of recovery support, does a community have the infrastructure? We're looking at CORE has funded 11 recovery community centers. And I think we're seeing really good preliminary results from that. And basically what that is it's a landing spot for someone in the early stages of recovery, where it's a safe place to go, where they can build community with other folks that are in recovery. They can attend all their meetings. They can get job skills training, access to education help. That's really where we're seeing a lot of the movement. And then also in the literature and the science, the nascent area of recovery science, we're seeing that these are sort of the pillars of an effective community response. And so that's what we're looking in our criteria to help support and promote.
Let me, I know you've still got more to say, but let me ask real quick. Have you gotten, Van, you mentioned you're going to go see Keiko. You are going to see Keiko in November. Have you already met with league or with members?
Yeah, Dr. Katie Marks and I did a training there at the League of Cities.
Was the interest pretty good?
It was pretty good. And talking to JD, there seems to be a lot of mayors excited about this program. And I've talked to Shelley, and a lot of counties seem to be interested in this program. So I don't think it's going to be a heavy lift to get communities to participate. I really don't.
The only other question I had, and I didn't mean to cut you off, Dallas, but I wanted to ask if you've heard from, I know there's chamber representation on that council, but I'm curious from a workforce perspective if there's interest in what we're doing.
There really is. I have a grant with the Chamber Foundation to do trainings for employers to become recovery-ready employers. They held their first academy last year. I thought they'd be lucky to get 10 businesses that wanted to participate in a 3-day academy. They had to turn people away. They had to stop at 20 because there was just so much interest. We're going to do 3 more academies in 2023. Just that first academy represented 20,000 employees. So the business community has already figured out we have to tap into this workforce of people in recovery and people that have
that's really encouraging.
Have a felony background due to their addiction. So I've been real excited about the participation and that we've had from the business community, and chambers are a great partner to have to do that.
Yeah, and the local chambers as well have been stepping up and attending our community meetings and town halls. So yeah, again, very heartening of the response. And then finally, I just wanted to open it up. That's our.
See, I could have just let you get to the last slide. I couldn't keep my mouth shut.
But no, we would love to hear from everybody, and please disseminate this far and wide. We want as much input as possible. Again, we're trying to make the best product to empower our communities to address this issue, which is one of the issues of our time.
And just to let you know, I don't know, Chairman knows, Westerfield knows, but the rest of you, we put out our first draft early this month to the council. They've had a few weeks to kind of look that over and think about it, and we've taken some feedbacks and follow-up from some of them. And we'll meet again, I think it's December 1st, and present to them what we believe hopefully will be a final product. And then we hope in the first quarter of 23, we're certifying communities. That's our goal.
Well, I want to. It's exactly what I wanted you to present, and I'm glad that that's your final slide. So I hope everyone takes that address down, and I want to make sure that Roberta, if we can send that specifically to all committee members by email. I want to remind people to encourage them to get their local folks involved and to weigh in. It's exactly what I wanted y'all to have to be here to present. We do have a couple of questions. Representative Bratcher.
Thank you, Mr. Chair. One time I was talking to someone and I said, "You're not fixing the drug problem in this state." And they told me it's less about fixing it, ending it, and it's more like you got to cut your fingernails every few days. It's always going to be there. Number one, do you guys agree with that? And I have more questions after that.
So look, I don't think Washington, D.C. is going to fix Kentucky's drug problem, and I don't think Frankfurt's going to fix the next community over, Nicholasville's drug problem. These issues are going to be solved community by community. That's the way grassroots changes always happened in this country, is at that grassroots level. I think that's what it's going to take. So can every community make things a little better? I think they can. Can we ever do away with substances? No, that's never going to happen.
Well, one of your charters on the Office of Drug Control Policy is that you're going to reduce substance abuse.
We try.
Now, you've been in there since 2004.
Yeah.
Is it being reduced?
We've had some successes and we've had some setbacks. Certainly, 2020 was a huge setback. A lot of these things we can't control. We can't control that cartels have gone to a situation where fentanyl is involved in every illicit drug on the street, that they're routinely taking fentanyl and making it look like a legitimate pharmaceutical and then selling them on the streets. Those are the things we don't have control over, so we have to control what we can, Representative Bratcher.
And I appreciate that, and I appreciate everybody at the table. I know you're working, doing God's work, the right thing. But sometimes I think we come down here and all we're doing is building a bigger Band-Aid for a problem that I guess is just too big for Kentucky.
I get frustrated too, sir.
Yep. And I represent the taxpayers, and I don't know how much tax money going into this program. I better do my homework, but it's just like I wish we could get some good news if we're going to put all this money and effort into stopping substance abuse. And so there it is. Thank you.
Senator Carroll.
Thank you, Mr. Chairman, and thank you all for the presentation. Van, we've talked over the years, and there's obviously been a huge shift towards treatment and programs popping up all over the Commonwealth. And we've talked about not really having the ability to not coordinate, but to be able to gauge the success, to pull all the data together so we can, as we invest money each session, each budget session, that we know which programs are working and which programs aren't working. Where are we along those lines, and do we have a structure in place to monitor these various programs and their success? Is all of this being combined into a central database? Where are we on that?
We're in process. The Kentucky Opioid Response Effort, Dr. Marks' group, has done a really good job with Medicaid claims data. That's the best source of data for us as a state government is those claims data.